Barony of Grey of Codnor, Lord Wilberforce.
My Lord, I have the honour to present to your Lordships the report of the Committee for Privileges in this matter, and in due course to move that it be accepted by your Lordships. The case concerns, as your Lordships know, the Barony of Grey of Codnor, arising out of a petition from Mr. Charles Shuldham Lee, Cornwall Lee, to have the abeyance of this barony terminated in his favour. And the report of the committee is submitted in House of Lords paper 1759, a pleasantly but rather deceptively slim volume, but is accompanied by a supplementary volume 59/1, which contains a more detailed report of the proceedings of the committee, part of which your Lordships may find rather good reading. The report itself, as your Lordships see, contains 8 recommendations in effect, which I shall be drawing to your Lordships' attention, accompanied by a learned opinion from my noble and learned friend, Lord Jauncey of Tullykettle, which will apprise your Lordships of the difficulties of what would appear to be otherwise a simple case. My Lords, I feel that a little explanation, not in the nature of a lecture, I hope, but a little explanation is necessary to your Lordships in this case for 2 reasons. First, there has not been a case of an abeyance brought before this House for 50 years. And not all of your Lordships, I think, were present at that time. Secondly, the case itself is a bit unusual, if not startling. The abeyance itself has lasted for 493 years, which is not a record. There has been found a case of 547 years. But one must agree that even by the standards of your Lordship's House, 493 years is rather a long time. Moreover, the present petitioner, Mr. Cornwall Lee, has himself claims only 1/12 of the dignity, 1/12 part of the dignity, which again gives one pause for thought. And that makes it necessary to make it clear to your Lordships that this is a case, a rather exceptional case, of a barony by writ. A barony by writ, which is a peculiar type of peerage. Originally was the primary source of peerage, because peerages by letters patent only came in the 14th century, and of which there is quite a number of representatives now in this House. But still, your Lordships may not be quite familiar with the distinctive features of a barony by writ. My Lords, those are 2. First of all, as to origin, there is no document which describes the nature of the barony by writ or describes its tenure. The barony by writ arises, as one would think, from a writ of summons from the sovereign to attend Parliament, followed by, and this is very important, followed by attendance, actual attendance, and sitting in a Parliament, a properly constituted Parliament by the person summoned. My Lords, the necessity for personal attendance on top of the issue of a writ was, it appears, invented by that great lawyer, Lord Cook, in the 17th century. And nobody's been able to find out what he based it on, but there was obviously good sense, because otherwise the House would have been deluged by people who would claim that writs had been issued, and the necessity for actual sitting was obviously a sensible way of keeping down the numbers. At any rate, that has been accepted ever since then, the necessity of sitting pursuant to a writ, and your Lordships will see that that has an important bearing on the recommendations in this case. So much for origin. Then one comes to the matter of descent. Of course, if you have a peerage by letters patent, as most of your Lordships do, the patent describes the nature of the descent, heirs male to heirs general to heirs female, for life. It's there in the document. You don't have to look any further. But in the case of a writ of summons, a peerage by writ of summons, there is no document. and therefore descent depends on the common law and goes to heirs general. And that brings about this situation of abeyance, because it may often happen, it does happen, that if the holder of a barony dies without male heir, and only females succeeding him, daughters or aunts or collaterals, then the females take as co-heiresses, no one of them being entitled to the barony. It's what is called impartible. It is there, the three co-heiresses have it, but no one has it in preference to the other, and it is in abeyance until that situation is terminated. And that situation remains until the abeyance is terminated, either through all the shares becoming reunited in one person, or by the discretion of the sovereign. There's one other important point about the descent, and that is the co-heiresses take equally. There's no seniority, no primogeniture. The older has no preference over the younger no preference over the older. And there are cases in the books where these peerages, these abeyances have been terminated not in favour of the older of the co-heiresses, but in favour of the middle one or of the younger one. Well, there we are, my lords. The position is that the peerage is in abeyance, not having been amalgamated in the person of one single heir. And what happens next, if you wish to terminate it, is that a person, one of the co-heirs, puts in a petition to the Crown asking for termination in his favour. And the Crown normally takes the advice of one of the law officers, the Attorney General. The Attorney General reports on the matter. He can either recommend acceptance of the claim, or he can recommend rejection of the claim, or he can recommend that the matter be referred to the House of Lords. And that makes the important point that reference to the House of Lords is facultative, it is optional. The House of Lords has no right to be consulted, though it often is. This is entirely in the discretion of the sovereign through the Attorney General. And when it comes to the House of Lords, the task of the House of Lords is strictly limited. It is to establish the facts, and it is for the establishment of the facts that the matter is referred to the Committee for Privileges. I think I ought to refer your lordships to the actual reference in this case in order that you may see what the duties of and what are the limitations on the duties of this House on this occasion. I'm looking at the reference in this case, which was in these words: His Majesty, and I think that was King Edward VIII, His Majesty being moved upon this petition, is graciously pleased to refer the same to the Right Honourable the House of Peers, to examine the allegations thereof as to what relates to the petitioner's title therein mentioned, and to inform His Majesty how the same shall appear to their lordships. And that is November the 3rd, 1936, signed John Simon. So that is the reference on which your lordships are now called on to act, and on the facts being found by the Committee for Privileges, if accepted by this House, then what next happens is that the matter goes to the sovereign, and it is in the sovereign's discretion then to decide about the determination. The sovereign may decide either not to determine at all, or to determine it in favour of any one of the co-heirs. This is not a matter for your lordships, unfortunately. It's a matter for Her Majesty on taking, no doubt, appropriate advice. Now, my lords, I ought to mention two other points which arise out of the dates which I have given. Your lordships may know that this House has previously been very concerned about the number of these abeyances, these abeyance claims, often dating a long way back into the mystic past, which have come up and have given rise to a great deal of inquiry and difficulty. And so in 1926, this House established a select committee under the chairmanship of the noble and learned Lord Sumner, of course a distinguished Lord of Appeal, to inquire into the matter. And the Sumner Committee produced a very interesting and learned report going into the whole history of these abeyances and these peerages, and submitted a number of resolutions for presentation to His Majesty, King George V. And that was done by an address presented His Majesty, which His Majesty accepted. His Majesty retains an ultimate discretion, but nevertheless the recommendations are those of the Sumner Committee and are normally thought to govern each case. There are two important points contained in the recommendations. First, that no abeyance should be considered which was longer in date than 100 years. Secondly, that no claim should be entertained unless the claimant lays claim to at least 1/3 of the dignity. So your lordships can see at a glance that this particular petition would have fallen foul of, on both of those counts, much more than 100 years, much less than 1/3 of the dignity. But what happened was this. The matter was referred by His Majesty to the Attorney General, Sir Thomas Inskip, in July of 1928. And he produced a report. He gave a long advice examining a number of the facts, which has been very valuable to us. And he took the point that as the claimant, who was then the present petitioner's father, had submitted his claim before the Sumner address was presented to the sovereign, he should not be bound by the limitations in those recommendations. And therefore, in spite of the fact that he was outside the recommendations, his petition should be admitted. However, that the father did not proceed with his claim. He died in 1934. And the petition was then revived by his son, the present petitioner, in 1936. The next Attorney General, a succeeding Attorney General, Sir Donald Somerville, then took the matter under advisement, and one may think rather benevolently, decided that the son should have the benefit of the relaxation of the rules granted to the father, and therefore that the son's petition too should be allowed in, notwithstanding the Sumner recommendations. So on that, the present reference was made to the House of Lords, and your Lordship's committee took the view that it having been made, whatever we might think about it, we were bound by the reference, we were called on to act under the reference, and we must do our duty under the reference. One must, of course, add that no similar claim could now be made with any hope of success, because it would clearly be excluded by the Sumner principles. My Lord, the second point is also rather startling. Your Lordships noticed that the reference by Sir John Simon to this House was so long ago as 1936. Of course, one expects that peerage claims should proceed at a somewhat dignified and leisurely pace. But 53 years is, by all standards, a little slow. So when I had the honour of being nominated as chairman of your Lordship's committee in June of this year, I thought we'd better look into this, and I asked for the file. It was a very bulky file, was obtained from the administrative portion of this House, and it appeared that the present claimant had submitted claims for prolongations, adjournments, extensions of time to the office on a number of occasions during this period, which had been granted on account of World War II, on account of his public duties, on account of expense and so on. At any rate, extensions were given from 1936, going very nearly up to the present time. And on that, and with the, without the disapproval of the Solicitor General, your Lordship's Committee took the view that it would not be right to blame the petitioner for this delay or to exclude him from the doors of the committee on account of it. So we entertained the claim. Now, my lords, I come at last to the report. The committee made a very careful inquiry into this matter. There's very detailed evidence put before it in the form of 105 propositions, each of which were supported by detailed evidence. The detailed evidence extended into a great number of documents, I think taking 1,000 pages, though that may be a little misleading because one shouldn't double count both the medieval Latin and the translations. But at any rate, a great number of pages, a great number of documents of great interest, as well as heraldic evidence and tombstones and so on had to be looked at. And all this was very carefully checked by the Crown through the Treasury Solicitor's Office, very carefully analysed for us by the Solicitor General, and we had the benefit of some very learned evidence from Mr. Woodstock, the Somerset Herald. And on the basis of that, these recommendations were put forward. If your lordships are good enough to look at them, I can dispose of them fairly quickly. The first is that the Barony of Grey of Codnor is an ancient barony in fields, no doubt about that. The second one requires a moment of attention, because it states that it was proved by the sitting of Richard de Grey in Parliament on 17 December 1397 that the Barony of Grey was vested in the aforesaid Richard de Grey in the reign of Richard II. My lords, the case as originally put forward was that an ancestor of Richard de Grey in 1298 was first summoned to Parliament, and that is undoubtedly the case. Each of the three so-called Lord Barons of Grey were summoned to Parliament, but your Lordships Committee was not able to find any evidence that they actually sat in Parliament. Indeed, the petition of the petitioner does not allege that they sat in Parliament, and your Lordships will appreciate the difficulty of establishing that a particular man did sit in a particular Parliament, and that Parliament was a properly constituted one. However, we were perfectly satisfied, and your Lordships will find this analysed in detail in the opinion of my noble and learned friend, that Richard de Grey, the fourth Baron, did sit pursuant to a writ in 1397, and with the consent of the petitioner himself and with the approval of the Solicitor General, your Lordships Committee decided that the right date to take was 1397, rather than the earlier date of 1298. And that, of course, is of some importance from the point of view of precedence, because it would be a matter of considerable hesitation before your lordships were inclined to displace a number of well-established baronies in due order of precedence. They should clearly not do so without very clear evidence, and therefore we did not feel it was right to predate the barony earlier than 1297. 1397. Now, my lords, as it is said, this is really fairly simple in presentation, though it took a lot of time to investigate. Your committee found that there were three co-heiresses of the last Baron who died without legitimate, though not altogether without illegitimate issue. They seem to have been very estimable people, incidentally, and were very well provided for by the Baron at the time. If your lordships turn to page 6 of the report, you will find a short summary of the heirs. This is taken from my noble and learned friend's opinion. There are much detailed pedigrees, of course, in the report of the proceedings. You will find there three ladies in capitals, Lucy, Eleanor, and Elizabeth. And one of the main points which troubled the committee was whether those three or all of them ever existed, it being clear that Elizabeth existed, but some doubt as to the existence of Lucy and Eleanor. At any rate, your lordships came to the conclusion, mainly on the strength of a document of Henry VIII and some valuable heraldic evidence, which satisfied us that both Lucy and Eleanor existed as co-heiresses as well as Elizabeth. Your lordships will then see under Lucy Thomas Cornwall, that is the descent to which the present petitioner claims, and the other co-heirs claim through the other branches. Under Eleanor, the present 7th Earl of Bradford claims as a co-heir, and under Elizabeth, your lordship will see in a moment that there is something of a problem. If you turn back then to little 3 in the resolutions, you will find there the finding that the barony fell into abeyance between the heirs and co-heirs of the 3 paternal aunts, Lucy, Eleanor, and Elizabeth Zouche. And then 4 goes down to deal with the representatives co-heirs of Lucy, and those persons are listed. And there are detailed pedigrees, if your lordship wish to consult them, of those persons. But your lordship should notice the last words which say the heirs, if any, of Mary, younger daughter of the 11th Lord Zouche. That is a case where inquiries ran into the sands. We were not able to find out whether Mary, daughter of the 11th Lord Zouche, did have any heirs or not, and therefore that has to be left uncertain. 5 is a clear case. The descent is clearly traced down from Eleanor Newport down to the 7th Earl of Bradford, now sitting in this house. 6 deals with the case of Elizabeth, as to which we were able to find that she had issue, but were not able to find whether any descendants of such issue now exist. So that, my lords, and this is quite in accordance with practice, the committee is required, and the petitioner is required, to satisfy the committee that all proper and possible inquiries have been made with a view to tracing these particular classes of issue, and the committee is entitled to find that such proper inquiries have been made and investigations conducted, and to put forward its report on that basis. And that is what we've done. And finally, therefore, we come to the conclusion that the barony is in abeyance before the aforesaid representatives and co-heirs, and the heirs of any of the said Elizabeth Zouche. That comes to the petitioner and 12 people, and finally that the barony of Grey is at Her Majesty's disposal. So as I've already, I hope, made clear to your lordships, it is now a matter for Her Majesty to decide in her discretion what to do with the barony. The facts have been found by the committee. If your lordships consider that the committee has done its job and has achieved the task referred to it by the Home Secretary in 1936, your lordships might think fit to agree with this report. I beg to move that your lordships accept it.
Is the motion be agreed to?
My lords, having heard the noble and learned Lord Wilberforce, I am absolutely amazed and horrified slightly by my temerity in daring to put my name down to speak after him. This morning, as he has said, we are witnessing the final stage of the appeal to the Crown to determine the abeyance of the ancient Barony of Grey of Codnor in favour of the petitioner, Mr. Charles Cornwall Lee. The noble and learned Lord Wilberforce, in his splendid oration on the medieval peerage and his most detailed explanations, has put us all heavily in his debt. I should perhaps just mention that 2 of my peerages are of the sort known as by writ, which he so well described, and my 3rd peerage of Stourton is by letters patent, so I'm an animal of both types. As he pointed out to us, it's now 83 years since the petitioner's father began what was to become this very long case, and as has been said, 493 years since this peerage was last in existence. This probably will be the last such case to be allowed, as in 1927, as the noble and learned Lord told us, it was recommended that no petition for the determination of an abeyance should be entertained if it had subsisted for more than 100 years. But of course an exception was made for this particular barony, as it had not got into the pipeline, so to speak, as it had got into the pipeline, so to speak, just in time. The last case previous to this dealing with such a long abeyance was, of course, the ancient barony of Straboghi, called out in 1916 in favour of the grandfather of the present distinguished holder of that title, himself a member of the Committee of Privileges, whose report we are now discussing. I find it interesting, my lords, that the last Lord Grey of Codnor left a widow on his death in 1496, who was Catherine, and she was sister to my direct male ancestor, Edward VI Lord Stourton, and she enjoyed her grey jointure till her death in 1521. Another point of interest for me about the Greys of Codnor is the fact that they were responsible for bringing the Carmelites to this country and settled them on their estates at Elsford in Kent, where the priory of their foundation continues to flourish, very remarkably, still with Carmelites. The noble and learned Lord, Lord Chauncey of Tullyckettle, played a leading part in this Committee of Privileges, and possibly it is the first time that a Scots legal brain has been found in a law dealing with an English peerage case. And I found his broad sweep of inquiry most refreshing. The finalization of this case is going to give very great pleasure to one whom I consider one of the greatest genealogists in Heralds, namely Sir Anthony Wagner, now Clarenceux King of Arms, a former distinguished Garter. It was he, my lords, who was in charge of the research in this case from 1936 until 1983, when illness forced him to hand over the completion of the work still remaining to be done to Mr. Thomas Woodcock, Somerset Herald. It was Mr. Woodcock who was able to overcome one of the last difficulties by a piece of heraldic evidence, found, curiously enough, owing to a new form of the compiling of a new index of heraldic arms in the college by Sir Anthony in his time. It is amusing to think that it is only 140 years ago that Disraeli produced his Sibyl, where he invented Mr. Hatton, the famous peerage lawyer of the Inner Temple, who explained to a client, "If you wish to be Lord X, I will undertake to make you so, and will give you precedence over every peer on the roll except 3, and I made them, and it will not cost you a paltry 20 or 30,000 pounds." Well, the days of the Mr. Hattons have long gone, and it is refreshing to see the result of such long labour and research rewarded by such a succinct report to this House, and I congratulate the noble and learned Chairman and all the other members of the Committee of Privileges.
My name is not on the list, but I have been told that I can speak briefly with your Lordship's leave. I wanted to say very little other than to thank the noble and learned Lord Wilberforce, not only for moving this motion, but also for the way that he moved it, and to say that it was a truly great personal privilege to be able to serve under his chairmanship. And I think that your Lordships would wish a word of tribute to the noble and learned Lord, not only for his industry in sorting out a mass of complex material. The noble and learned Lord said a bulky file. My lords, there were many bulky files with family trees and so forth. And his industry, not only in sorting that out, but his expertise in having sorted out before we sat, in leading us all to the salient issues. And without that, this hearing could have taken several weeks instead of a matter of days. My lords, a word of gratitude is due to the noble and learned Lord Chauncey of Tullyckettle for his most detailed and erudite opinion, with which all members of the committee agree. And I suppose, my lord, that one can end with a word of congratulations to my noble friend, Lord Mowbray and Stourton, who remains Premier Baron, albeit by a whisker.
My name is not on the list either, and the only reason why I would seek to make a very short intervention is not because the government has any view on this, because it doesn't, but simply to thank the noble and learned Lord Wilberforce and his committee for what they've done. My noble friend Lord Campbell of Alloway said that he had the privilege to serve under the noble and learned Lord Wilberforce, and he found it a great privilege. All I can say is that I find it an enormous privilege to listen to the noble and learned Lord Wilberforce. His speech really did contain history, genealogy, and documents in Latin, and it was fascinating. My lords, we are deeply grateful to him. And the noble and learned lord did say that he didn't wish to divest himself of a lecture had anyone put his speech into such a category. And nobody did, nobody would. I can assure him that it would have been a very acceptable lecture.
My lord, I need say nothing more in closing this, except to remedy an omission. I notice that the report does not contain the names of the Committee for Privileges set up by your lordships. I think your lordships should know that it consisted of noble and learned Lord Elwyn Jones, of course, with great experience as a law officer, noble Lord Strabogie, whom reference has been made, who was associated with these matters personally, noble Lord Campbell of Alloway, and my noble and learned friend, Lord Johnsey of Tullyshethel. I'm very grateful to them for all the support which they gave, for the kind words which have been said. I would like to add our gratitude to the staff of the Judicial Office, who showed very great efficiency in printing all these documents and making them accessible to your lordships, and so enabled this matter, which only started its way with the committee in June of 1989, to reach this final stage just before the end of this session. Lord, I think that that may console us a little bit for the very long period which elapsed before then. I beg to move.
The question is that this motion be agreed to. As many of that opinion say content, the contrary not content. The contents have it.
My lords, I have to inform your lordships that Her Majesty has been pleased to determine the abeyance of the Barony of Grey of Codnor in favour of Charles Lee Shildham Cornwall Lee. The barony fell into abeyance in 1496 on the death of Henry, Lord Grey of Codnor, from one of whose aunts the present Baron descends. The noble lord now attends at the bar with his writ of summons to take his seat.
I, Charles, Lord Grey of Codnor, do swear by Almighty God that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth, her heirs and successors, according to law. So help me God.